Dr. Intan?
Thank you, Mr. Deputy Speaker, for the opportunity to speak on this bill. I stand in support of this bill, which seeks to provide more extensive protection and better and fairer provisions for young persons up to the age of 18 years in their best interests. First, I would like to speak on Clause 4, which amends Section 4 of the Act. I support replacing emotional injury with emotional harm. Injury tends to suggest that the abuse is rather tangible or explicit and is visible, while harm is more all-encompassing and suggests that while it may not necessarily be visible, the damage the abuse has caused is much more far-reaching and may manifest itself in ways other than that which is visible. There are cases where parents or guardians, in their fervor to bring out the best in their children, end up subjecting the child to emotional abuse or acts of degradation that erode the child's feeling of self-worth, self-esteem, or overall well-being. Some parents see their scoldings and nagging or even acts of punishment as necessary acts of discipline for their children. Where and how do we draw the line? And when do the authorities step in? Do we intervene when a member of public complains? Or do we wait until a significant adult in the child's life, such as a teacher or an adult relative, takes notice and informs the authorities? Or do we need to wait until the child who is a victim of emotional or mental abuse speaks up or seeks help? I seek clarification from the Ministry as to where and how do we draw the line with regard to a child or young person being in need of care or protection, as well as when do the authorities step in. I am a parent too, and I do understand the expectations some parents have on their children in wanting them to realize their full potential and do well in school and later on in life. But we should not condone authoritarian or even authoritative parenting that revolves around scoldings or punishments or persistent nagging or acts of degradation which are essentially abuse towards the child. As a parent, love should always be the basis of our care and discipline towards our children. We can certainly discipline our children and be firm with them in order to instill good values, but this should be done on the basis of love and care and not on the basis of hate or wanting to inflict fear or pain. Some children do suffer as a result of the parent's style of parenting. Some suffer in silence, while some start to develop a facade of indifference, while some of these emotionally or physically abused children would in turn inflict pain on others who are in a position more vulnerable than they are, such as a younger sibling or a classmate or schoolmate. Hence, I support the amendments to Section 4 to expand and set out the circumstances in which a child or young person may be regarded as being subject to emotional or psychological abuse and would need care or protection beyond that which can be given by their biological parents or legal guardians. With these amendments, I hope more protection and the necessary care can be extended to the children or young persons who have otherwise been subject to abuse or harm by those who should have been protecting them. Next, I would like to speak on the fostering of young persons. I am supportive of the formation of the Committee on Fostering. I believe this will help provide a more objective and fairer platform for the review of foster care to be provided to young persons who have to be removed from the care of their biological parents or even foster parents. Within the last 1 year, I have had 2 families living within my constituency who came to seek help regarding their foster care arrangements. One of them, a couple with grandchildren, had been foster parents to a young girl since she was only a few weeks old. The gentlemen of this couple, who are foster parents, let's call him Mr. C, had alleged that the Ministry of Social and Family Development, or MSF, had acted in a biased and unfair manner towards him and his wife, and had, what he claimed, listened to and sided unfairly with the girl's biological father. As a result, the girl was taken away from their foster care to be reunited with her biological father. As expected, Mr. C was furious. He claimed that MSF had taken decisions on the matter, quote, with no regards to the child's well-being, unquote. I had asked MSF to review the appeal made by Mr. C to return the girl to his and his wife's foster care. MSF had reviewed the case extensively, and I learned that it was Mr. C's wife who had decided to discontinue care as a foster parent to the child in the first place. Another couple, Mr. S and his wife, have been foster parents with MSF for about 9 years. They have cared for 3 children since then, with 2 of them still living in their care. A third child, the youngest of the 3, was under their care for about 6 years until he was removed from their care recently. Mr. S and his wife were distraught and claimed that MSF had taken the boy from their care with little notice and without considering their inputs and views on the matter. They also claimed that the boy did not want to return to his biological mother, who had recently been released from prison. Again, as expected, Mr. S and his wife blamed MSF and claimed MSF had acted unfairly and did not consider the best interests of the child. In both instances, I can fully understand the feelings of the foster parents. They had given their time, care and love towards the child they had fostered and cared for over several years. And inevitably, a strong emotional bond would have been formed between the foster parents and the child over those years. To let go of the child once their foster care is no longer needed is not an easy thing to do. At the same time, I must state my support for the work that MSF does. As a ministry, it has to look at each and every foster care case with objectivity and fairness and in the best interest of the child in question. It is unfortunate that when a foster care case does not turn out the way that the foster parents or even biological parents expect, it is somehow expedient to blame the MSF and the MSF officers working on the case for it. This is very unfortunate and unfair indeed. Hence, I feel that the insertion of Clause 23 in the bill to include a new Part 2A on fostering will be useful in delineating the rules and provisions for fostering, particularly in setting up a committee on fostering made up of individuals appointed by the Minister, who may be able to provide inputs and opinions from a seemingly more neutral and balanced perspective. If possible, I would propose that the Minister include relevant professionals who would be able to provide significant inputs on the well-being of the child. These relevant professionals could be medical psychiatrists, clinical or child psychologists, school counselors, and education professionals, among others. I would also propose that this committee consider for each foster case that is being contested or disputed to interview the foster parents, the child or young person in question, and biological parents to better understand their motivation for wanting a particular outcome pertaining to the foster case, even while they consider the report and recommendations made by MSF. Eventually, these different inputs of important information can be put up as recommendations to the court dealing with a particular foster case, if need be. Likewise, I would propose that where an order related to fostering is made by a youth court, this Committee on Fostering is able to make recommendations to the Director General of Social Welfare in deciding on any Category 1, 2 or 3 matters relating to the child or young person, including the identification of a fit person to which the care of the child or young person is assigned. Here, I would like to state my support for childcare leave, extended childcare leave and unpaid infant care leave to be extended to foster parents who have opened up their hearts and homes to these vulnerable children and young persons in need of love and care. Our foster parents also need the parental-related leave to care for their foster children. One aspect of this bill that I would like to seek clarifications on is Clause 48 with the introduction of Section 68A. I'm somewhat concerned with the provision to allow the person in charge of any home for children and young persons or any other authorized persons in that home to use a mechanical restraint on a person detained in the home, called a detainee, in order to prevent the detainee from escaping from custody or to prevent the detainee from inflicting any bodily injury on themselves or on others. What forms of mechanical restraints are allowed to be used? To what extent are these mechanical restraints used? And what if the mechanical restraints used inflict even more injury on the detainee than that it was first meant to prevent in the first place? Hence, while I understand the need for restraints for violent or hostile behavior, how does the Ministry decide on a balance of probabilities and outcomes when and what forms of mechanical restraints are to be used? At this juncture, Mr. Deputy Speaker, please allow me to speak in Malay. Cabaran dan masalah yang masyarakat kita hadapi bukanlah sesuatu yang remeh atau yang mudah dihuraikan. Pelbagai faktor boleh menyebabkan sesuatu cabaran atau masalah yang dihadapi sebuah keluarga dan huraiannya juga merangkumi pelbagai faktor dan sumber bantuan. Memang masih ada ruang bagi huraiannya diperkukuhkan. Namun demikian, kita harus akur bahawa pelbagai inisiatif telah dilaksanakan pihak pemerintah untuk menguraikan cabaran atau masalah yang dihadapi masyarakat dan keluarga kita, seperti pertubuhan M Kuasa 3 yang melibatkan gabungan usaha dan sumber tenaga dan juga dana dari MUIS, Mendaki dan Mesra, iaitu pertubuhan akar umbi dan usaha para sukarelawan. Pertubuhan M Kuasa 3 ini khusus bagi membantu keluarga di kalangan masyarakat Melayu Islam kita dan melibatkan juga kerjasama MSF. Ini adalah satu usaha yang baik yang telah menunjukkan kesan menggalakkan dan positif dalam memperkukuhkan keluarga kita, mempertingkatkan kemahiran dan peluang pekerjaan kita, mempermudahkan akses pendidikan berkualiti lagi yang dimampui, dan juga melaksanakan inisiatif-inisiatif tertumpu pada kebajikan anak-anak kita. Kita harus terus menyokong matlamat dan usaha inisiatif-inisiatif pemerintah seperti M Kuasa 3. In English, please, Mr. Deputy Speaker. The care of children and young persons who are removed from the care of their biological parents or from their foster parents will always be a sensitive and emotive matter. and where emotions run high, rationality and judgment may be clouded. I do not envy the work of MSF in dealing with such sensitivities, and I hope the amendments to the Children and Young Persons Act will strengthen the provisions to be made and for fairness and objectivity to prevail in ensuring the best interests of each child or young person in question. Notwithstanding the clarifications I sought earlier, I support this bill.